Today's lesson covers the fundamental skills of briefing cases and writing essay exams. And I am so excited to present this lesson to you because if you master these skills at the beginning of your law school career, you'll put yourself on a great trajectory to enjoy law school because you'll know how to use your casebook, what's going to be expected of you in class, and how to perform on your exam. My name is Professor Seth Orenberg, and I teach contracts and corporations at Duquesne, and I do research on topics like venture capital. I really enjoy making these videos as well. Today we're going to talk about a specific case. It's a case you haven't read, so I'll give you some of the facts and details. And we're going to use that case in order to build out our first brief. A brief contains many things. A case brief will often have a title or citation of the case, the facts of the case, issues, holdings, and reasoning. You might also find things like procedural posture. We're going to talk about each of those in turn. The title or the citation is the first thing you'll read in the case, and it actually contains a lot of information. We first look at the parties: Pavel Enterprises, Inc., plaintiff, appellant. We've learned something already. Pavel Enterprises is the plaintiff. They brought this case to trial court. That's the party that feels aggrieved. That's the party that wants the court to offer a remedy. In addition, by seeing that's an appellant, we know that the trial court refused to give them that remedy, and now they've appealed the case. On the other side, we have A.S. Johnson Company, defendant respondent. So this is the party that believes they were in the right. In fact, they won at the trial level, and now they have to deal with the case again on appeal. And the court that we're in is the Court of Appeals of Maryland, which is a state court, and that can be relevant for matters of procedural posture and substantive law. To understand the facts of this case, it's helpful to understand a few things about contracting in general. When an owner wants a building built or renovated, that owner will tell different contractors, general contractors, that it wants the entire job done. The general contractor's job then is to go and find the people who will do the specific individual components of the work. For example, a home is going to require a roof and flooring and air conditioning and windows, and it may be that different subcontractors are specialists in all of those different jobs, and the general contractor's job is to organize all of them. In order to win the job, the general contractor needs to give a good price, but he doesn't know what price to give until he knows what it will cost him. So, the National Institute of Health solicited bids for renovating its building number 30, and Pavel Enterprises wanted the job. So it asked various subcontractors how much it would cost to do different pieces of the work. One of the replies came from A.S. Johnson Company, who said that they would do the work for $898,000 for the HVAC, that's the air conditioning and heating system. Pavel submitted a bid of $1,585,000 to the National Institute of Health. Then Pavel met with Johnson to continue discussing the project. They had a little bit more back and forth about it, but before Pavel accepted the bid, Johnson found the error in their quote, realized that they couldn't do the job for the amount of money that they had quoted and still make a profit, and withdrew their offer. Pavel refused to allow this withdrawal to occur, and when NIH formally awarded Pavel a construction contract, Pavel found a substitute contractor and now sued for the difference, saying that they incurred an additional $32,000 in damages because Johnson breached. There are a number of additional arguments and quite a bit of color here, but I'm going to move on and just discuss the issue that we can use to develop our brief and our essay exam question. We start by addressing one of the issues that we'll include. Was the subcontractor allowed to withdraw its bid? We have a controversy here because there was an error in the bid and one party wanted to withdraw and the other party wanted to hold it. Was the withdrawal permitted? In your brief, you would mention that there were 4 different theories that could have made this an irrevocable offer. We're under the topic of irrevocable offers, and I'll point out that that's actually in your casebook. That's the title of this section. So you actually might have known the issue before you even read the case because it was in the casebook in that chapter. So keep an eye as to where in your casebook you are so you know what issues you'll be looking for. It turns out that there are 4 ways an offer can be irrevocable: an option contract, a firm offer, a bilateral contract, or a theory called detrimental reliance. we're going to talk just about detrimental reliance so we can move on to the issue writing part. When a general contractor reasonably relies on a subcontractor's bid in making its own bid to the owner, the sub may in some cases be stopped from withdrawing the bid. We're going to go through that process of understanding how, and we're going to apply a framework called IRAC. IRAC stands for Issue, Rule, Application, and Conclusion, and is one of the most simple and straightforward methods that's been frequently taught to write an analytical essay in law school and some other programs. You don't have to use it. In fact, there are quite a number of other ways to write. But I think this is a simple way to start, and it might give you the framing that you need. So now that we've talked about this a bit, let's see how IRAC applies in this case. Let's write the issue first. What's the issue? Is the sub's bid irrevocable because the general contractor detrimentally relied on it? What rule do we have? The case points out that Restatement Section 90, Subsection 1, the second restatement of contracts, has a test for detrimental reliance, and in this case, Pavel Enterprises turns that into a 4-part test. We would then next apply the facts that are in our case to this rule. I have them here. We'll go back to this in a second, and then we're going to write a conclusion about what courts will do. In other words, IRAC means that you begin by stating the issue you're going to address, and that's going to frame the topic for your audience. You'll follow up by stating the rules that pertain to this issue, as you've learned them from reading cases, statutes, and other sources of law. You'll then apply those rules to the specific facts at hand, using words like here and because to show that you're talking about a particular situation and giving reasons for your conclusion. And then you will state what is that conclusion. How is a court most likely going to decide about this issue? Let's get specific and actually go through this process, starting with the issue. I would suggest writing the issue sentence in the format of, the first issue is whether these facts create this law. For example, the first issue is whether the sub's bid was irrevocable because the general contractor detrimentally relied on it. So we've sort of set this up now. We know what the law we're talking about is. We've identified very briefly some of the parties. And in this one short sentence, we've shown that we have spotted the issue at hand and we're prepared to deal with it. So we'll next write the rule. The rule comes from the case, and as I understand the rule, Pavel Enterprises, that's the source, explains how the Restatement Second of Contracts, sort of the deeper source that it pulled from, sets forth the rule on how to find, this is the legal issue, detrimental reliance. What's the rule? You need to have 1, a clear and definite promise, 2, where the promisor has reasonable expectation that the offer will induce action or forbearance on the part of the promisee, 3, which does induce actual and reasonable action or forbearance by the promisee, and 4, enforcement of this promise is necessary to prevent injustice. That came right from the case. We probably did a little bit of work in our casebook understanding that rule and all the words that are contained in it. We talked about it a bit in class and clarified understanding, and as you're making your outlines, you again reiterated the rule, and hopefully in a study group setting, you practiced expressing this rule so you were prepared to get that rule communicated in your exam in this format. The analysis section, that's where the rubber really meets the road. Here's where you get to work as a lawyer. Understanding the rule, that's a good start. And it's challenging in the first couple of months to even just get your head around what these rules mean. But now you actually have to operate them, put them into practice, and we're going to step out of the book and into the real world. Combine the two and come to a conclusion that you can use to help a client. We're going to do that by starting with the word here, identifying that we're moving from the law in general to the specific facts of this case. We're going to reiterate the issue or sub-issues as we go through. We're going to identify what is the legal status in our opinion, right? We're expected to have opinions. We need to have opinions about what the law is, and we want to state our reasons why. Those reasons are fundamentally important, especially as law students, showing that you understand how these things work. So let's try it out. Here, the sub's bid is sufficiently clear and definite to be an offer, and therefore a promise. Remember that the first rule was, do we actually have a promise? Well, here we do, because we had price and quantity terms. That's our reason for that. 2, the sub's reasonable expectation of contractor's reliance had dissipated. meaning there is no more reasonable reliance because it has been a whole month between when the bid process opening and when the bid was awarded. That's a long time, especially when, in addition, the sub said, don't rely on my bid, I had the numbers wrong. So we have our second quasi-conclusion, our mini-conclusion in 2, that we did not have a reasonable expectation of reliance in the sub. The contractor failed to prove that it reasonably relied. In fact, it was going around bid shopping, asking others for bids. So it must not have relied on the subcontractor's bid in that case. And finally, the court will ask itself, is it necessary to prevent injustice? And the reason the court gives in this case, on the facts of this case, is that it is not necessary to prevent injustice. And in addition, the fact that the contractor, the general contractor, was shopping around meant the contractor didn't have clean hands. He's not a good guy. And so we're going to be less inclined to offer this equitable solution to someone who didn't do all the right things. So finally, we conclude. Therefore, it is likely a court will rule that under these facts, boom, conclusion under the law. It is likely that a court will rule that the sub's offer was not irrevocable under the theory of detrimental reliance. Sometimes you have a clear conclusion, like here. Other times you might have to vacillate a little bit if the facts really were giving rise to 2 possible answers. But it really is best to try to answer and conclude clearly. Again, there's a lot of ways to do this, and I gave you a very simple approach. All of these steps cannot be applied in such a rigorous and uniform way, but this is a good start. If you practice this, you can then begin to build into your own writing ways to be more flexible, to address standards instead of rules, and sliding scales. And instead of looking at, in this case, a 4-part test, maybe there's a balancing test. In any event, thank you for watching. I look forward to next time.